The chair now lays out now. Yes. The chair at this time lays out House Bill 1910 and recognizes this author. Representative Dean.
Mr. Chairman, if it's okay.
Oh, and there is a committee substitute. Correct. At this point. And so is there any objection to the chair laying out this committee substitute for House Bill 1910? Chair hears none. The chair lays out House Bill 1910 and recognizes Representative Dean to explain it.
Mr. Chairman, if it's okay, I'd like to do it from here because I've got quite a bit of document. Thank you, Mr. Chairman. Members, HB 1910 affirms that parents should make private parenting decisions without court interference. Our current family code recognizes that certain parenting decisions are not properly reviewed by the court. For example, under current law, courts cannot terminate parental rights based on a parent's decision to homeschool. But increasingly, there have been reports of family courts in Texas intervening into parents' decisions regarding their child's gender. We have also seen parents, specifically when going through a divorce and custody battle, weaponize this issue, one parent accusing the other of abuse and neglect when that parent has only tried to do what they think is best for their child. These are powerful accusations. I know talking about gender and talking about children is a sensitive subject. There's some folks here that want to view this bill as an attack on a particular community, pitting one side against another. Let me assure you, HB 1910 is not targeting any group or any side. It's not trying to tell parents how they should reconcile their disagreement. Quite the opposite. HB 1910 is neutral on the treatment of this issue. The bill says courts should not be in the business of second-guessing parents' decisions. Specifically, HB 1910 makes three clarifications. One, a court may not terminate a parent-child relationship based on whether that parent has acknowledged or declined to acknowledge a child's gender. This addition puts the issue on the same grounds as whether the parent homeschools a child, whether the parent is economically disadvantaged, and whether or not the parent has chosen to vaccinate their child. Second, when a court is determining custody in a divorce case, the court may not consider whether the party has acknowledged or declined to acknowledge the child's gender. And thirdly, HB 1910 clarifies that a finding of child abuse cannot be solely based on a person's willingness or unwillingness to acknowledge a child's gender. Again, HB 10 seeks to respect that these private family matters should remain private and are not litigated in the courts. Finally, the committee substitute removes the term gender identity. I made this decision to reassert the neutrality of this bill. Since this term is not defined elsewhere in statute, and I am wholly committed to the impartiality of this bill, I did not want to distract from the purpose of the bill by debating definitions. One more thing. In the last few days, it's been brought to my attention that this bill would possibly affect children in foster care. We want parents that want to be with their children. Let me assure you that was never our intention. My goal is to remove this disagreement between the parents from our courts and protect parent rights. I'm happy to work with these groups to draft clarifying language. And Mr. Chairman, as of up until Monday, we had not had any group to come by our office to disagree with this bill, for the record. With that, I'm happy to entertain questions, and I ask to reserve the right to close.
All right. Are there any questions of Representative? I think Representative Talarico has a question.
Representative Dean, I know you're in your remarks, your hope is to push us into a neutral position in terms of these issues. But I think we would all agree if there's something that we consider abuse, neutrality makes us complicit in that abuse. So it seems to me the question is, do we think denying a child's gender identity is harmful to kids? So I guess that's my question. Is
That's not the position of the bill, Mr. Talarico.
Okay.
I care about kids. You care about
Yes, sir.
kids. This is to say that a parent should not lose their rights based on the other parent, considerations of that question. My bill is simply to say to the courts that that's not an area that should determine someone's losing their rights to their child.
Okay.
It's pure and simple.
Just a follow-up question, Mr. Chairman, if that's okay.
Go ahead.
Because what I'm concerned about, Representative Dean, is sometimes our LGBTQ kids get put into some harmful conversion therapy programs which have been demonstrated to be destructive for many of our most vulnerable kids. And so I'm just trying to figure out if we have a parent in one of these situations that's putting their child through one of those harmful conversion therapy programs, should that be considered?
It's not the intent of this bill, Mr. Tallery.
Okay.
I mean, I understand where
Sure.
you're coming from. That's not the intention of this bill.
Okay. Thank you, sir. I appreciate it.
Yeah, I think, some people have come by my office too, and I think there's been a misunderstanding about your bill, because as I read the bill, it is not harmful to any group of kids. What it says simply is that the court will not use that as the basis, your acknowledgement or non-acknowledgement of a child's gender selection as the basis for awarding a sole or joint managing conservator. And I think you'd want it that way, because to do it the other way would suggest that the court ought to consider that. And that, I think, would be the wrong step to take in terms of a court. A court shouldn't, that shouldn't be the consideration when deciding whether you're going to have a sole or joint managing conservator at all. And that's all this bill does. That's as far as it goes. It doesn't go any further than that. So if a child is, if there's a divorce proceeding and the court is looking at deciding whether one parent ought to be whether parents ought to be a joint managing conservator, or whether they ought to be the sole managing conservator, that's right. The consideration will not be in terms of whether or not they acknowledge or not acknowledging the child's gender identity. That's the way I read it.
Sorry, Mr. Chairman. Yeah, and of course I'm new to the committee, new to these issues, so I certainly want to defer to both of your expertise in the area. It's just my concern is, it seems like what we're actually saying is that denying a child's gender identity doesn't rise to the level of abuse. So we're making a value judgment by saying that this is not important enough to consider in these determinations. That's my concern, sir. When I'm reading
not the award. You mean not the awarding? On the first page it says that. On the second page, what you're getting at is it says abuse does not include a person's willingness or unwillingness to acknowledge a child's gender. That's what you have a trouble with.
Yes, you're right. That's my worry, is that we're saying this is not important enough to be considered, or that it's not appropriate to be considered in these courts.
Let's look at it the other way. Let's suppose this bill said abuse does include a parent's willingness or unwillingness. Yeah, that would be.
I think there are some folks and that would think that if you deny your child's gender identity, that's incredibly harmful, and whether or not we label it with the term abuse, I mean, it's abusive for sure. And so that's where I think some of us have concerns, and I don't want to speak for other members of the
well, should it say, are you suggesting it ought to say that it should include a person's willingness or unwillingness to acknowledge a child's gender? Or should it be silent as to whether that is abuse, whether it needed at all?
My just concern is ruling it out as not being abuse, I think, is dangerous and could certainly harm some of our most vulnerable kids in the state. And I don't want this to turn into a debate.
No, I'm trying to get there.
Yes, sir.
Because the way I see it is, if he has this in the bill, or if he does not have it in the bill, what does that mean? If you struck it out altogether, what would that mean?
Well, and sir, I don't think my concern is not just with page 2; it's also with page 1.
Okay.
I have just concerns, and I know Representative Dean is well intentioned. I'm trying to make sure I'm working through my concerns.
Right, right.
And
well, I was just trying to follow up with your objection about the abuse on page 2.
right,
Because I was trying to.
my concern is both on page 2 with saying this is not abuse, and also on page 1 with saying this should not be
I got that.
consideration.
We'll get to that one.
Yes, sir.
But what I was trying to do was take them separately.
Yes, sir.
So on the abuse side, if that's not in the bill, how would a child's gender be considered in terms of whether it was abuse or non-abuse?
You're saying if this section was taken out of the bill?
Yes, if it was not there.
I think that's a question for the committee of how that impacts the intent of the bill.
What I was trying to get at is, would a child's gender selection ever be considered abuse by CPS, for example, or parents' unwillingness to acknowledge that?
Right. I don't think it's the selection. I think it's the denial of that identity.
Well, I'm trying to figure out on the second page, though, how does that affect the first page? It
Right.
doesn't.
Yeah.
It doesn't affect the first page, I don't think, because on the acknowledgement of child's gender,
it does seem like they're separate.
it
Mr. Chairman.
doesn't talk. Yeah,
I would agree.
it doesn't talk about. It doesn't talk about abuse at all.
Right. I would agree.
That's not even a consideration in the first part of it.
Yeah, Mr. Chairman, I would certainly agree with you that the two don't necessarily seem to be linked legislatively.
Yeah.
But I do have concerns with both sections, but I agree that they're not necessarily kind of mutually exclusive.
Yeah. Well, I'm trying to get there with you.
Sure.
Yeah,
No, I understand,
because
sir.
I was trying to figure out.
And I know, and maybe it was just my office, but I did receive concerns from some advocates and
I did
advocacy
too.
group.
There were several people who came by, but I didn't get to talk to them. They talked to my staff.
Sure.
And so I didn't understand what the real objection was, because I started looking at it. If Mr. Dean takes line 11 and line 12 out of the bill on page 2, let's suppose that's not in there at all. What would abuse be in terms of unwillingness or willingness to acknowledge a child's gender? Would it? I wonder how that would come up. I don't think. Is there anybody here from CPS?
Mr. Chairman, are you asking perhaps how that would affect the child?
No,
as far as
I was
abuse?
asking whether or not CPS would consider that abuse if this is not in here.
Mm-hmm.
If it wasn't here, you know. So,
Do we have a resource witness? Mr.
I don't
Chairman?
know if we do or not. Well, we have a resource witness out here. Y'all scared to touch this? All right, well, whoever's got the answer, come forward. And tell us your name and who you are.
Good evening, Chairman Dutton, members. My name is Audrey Carmichael. I'm the General Counsel at the Department of Family and Protective Services.
Okay, good, thank you. And you're testifying on
Absolutely.
House Bill 1910. You understand the question I was asking? If this was not in the bill, what the bill says at the moment is, abuse does not include a person's willingness or unwillingness to acknowledge a child's gender. Suppose that wasn't in there. Would you ever consider abuse as a willingness or unwillingness to acknowledge a child's gender?
No, I think whether it's in or out, the impact to our practice and consideration of abuse would be the same. We would look at other things going on in the family, but in and of itself, that wouldn't drive our determination related to abuse or neglect.
And so it wouldn't drive you to, well, let me think about that. Okay. So if it wasn't in there, would you consider it at all in terms of examining for abuse?
It's not currently used by itself as a basis for an
Right.
abuse finding. So, I mean, if there were other things going on in the family,
Right.
you know, we've heard it kind of from both sides, whether it's affirming the gender identity or disaffirming the gender identity, but it really, you know, it doesn't.
When that happens, what do you use? How do you use that information? Or do you use
We
it
looked
at
at
all?
the current definitions, and I wouldn't say that in and of itself would really be a determinative factor.
So
for
you don't use it at all, is what I think I hear you saying.
Unless there were other things going on, like emotional abuse.
Well, yeah, I understand all those
Yeah.
things. I mean, you know, but just this one. If just this one existed, would you consider that abuse?
Just whether a parent affirmed or denied a
Yes.
child's gender identity. Nothing else? No.
Nothing else.
Mr. Chairman, could I ask?
Yes, sure. What can you tell me?
You mentioned emotional abuse, and again, I'm one of the non-lawyers on the committee, and so I'm just curious what constitutes emotional abuse.
So, and again, this is a very uncommon disposition. It's not one that comes up a lot, but the current definition, let me see if I can quickly get that for you. Okay. Hold on just a minute, it is here.
No, that's okay.
Okay. Right now, it's intertwined with the abuse definition for physical harm. So, causing or preventing the child to be in a situation in which the child sustains a mental or emotional injury that results in an observable and material impairment in the child's growth, development, or psychological functioning.
That's what you consider to be emotional abuse.
Right, the emotional part of that definition in 261.001 as it exists today would be our.
And I think to follow up on that was, if a parent does not acknowledge a child's gender identity, would that be ever considered emotional abuse?
And I said it comes up both ways. We've actually, I've never encountered a case. We've had people ask us sort of hypothetically.
Right.
So in and of itself, I don't see it. I mean, it would have to come with some other harmful
Or some other things like that.
language and some observable impairment to the child's functioning.
Right. Does that help you?
Yeah, just one follow-up, but I know
Okay.
other members have questions. If a parent were to act on their denial, meaning to enroll them in a conversion therapy program or something like that, where there's kind of active intent to change a child's identity, do you know if has that been brought up at all in terms of this definition of emotional abuse?
Not to my knowledge.
Not too much. Okay. I know this is new terrain for a lot of us here.
Yeah.
Thank you. I
Well,
appreciate it.
being proactive.
Yes.
Representative Kalani.
That's a question. So what would happen if, let's say, a child attempted to commit suicide, and then through the therapy with the doctors, it was determined that because they wanted to commit suicide because things they were having at home, would y'all then consider that to be abuse?
It sounds like something we might look into. Again, it's not solely, it's not just about the gender identity, it's the larger question of how's the child functioning in the family, what's being said to the child, what's being done to take care of the child,
But if this bill were to pass, then we wouldn't be able to find out any of that information. Because it's being prohibited.
I wouldn't think that the bill would prohibit us from considering other factors. I read it as only prohibiting us from considering the question of whether the parent affirms or denies the child's gender identity.
Right, but if the child attempted to commit suicide, and then they were in the hospital, and it was determined that the cause of the suicide attempt was because they are not being identified by their parent in a certain way, then you would not, if this bill were to pass, you would not be able to take that into consideration.
If that were the sole thing that the child was saying, not
Right. But that's it. That's all they're saying. Like, this is, I'm very depressed. I'm very sad about what happened. And so they attempted to take their own life. You would not be able to use that information if this bill were to pass.
Yes, I think, I'm just trying to think through the hypothetical where there's nothing else kind of playing into that it's solely about that. It's, it's not about, they call me names, it's, if that were truly the sole factor, then I would think the definition would make it harder to.
Well, I guess I was trying to follow up with the question, but the bill talks about a person's willingness or unwillingness to acknowledge. And in the case you mentioned about the child, having suicidal, or attempting suicide, if that was based on the willingness or unwillingness of the parent to acknowledge the child's gender, I'm not sure how you would make that, how you would make the link between the two unless something was done outwardly, other than the fact that they were showing an unwillingness or willingness to do it. There'd have to be something else. Right? Because what she's asking is, if because of the unwillingness, the child then attempted suicide, would you be able to get into that if this bill passed? And I was trying to follow it to see how that would, why you wouldn't. I have to think about it more. You have a question? Yeah, Representative.
Thank you, Mr. Chairman. I really didn't have a question, and I was following along. I think this discussion is very important because we know that emotional abuse does not leave physical scars. And so with that, are you finding that this is not a common thing in cases that you have to investigate in terms of if the denial of gender identity is emotionally abusive and leaves scars, or is this something that you haven't had to go through?
I'm not personally aware of any cases where that specifically has come up, and within our, 171,000 investigations a year, the few that do result in a finding of abuse, it's a minuscule proportion of that is emotional abuse already. It's just a less common thing that people call in about. But we could certainly get the numbers, but we just have not encountered this specific scenario.
Well, thank you. I really wish you would, and I think that some members of the committee, I can't speak for them either, but I think we would like to have that information because this is a real issue that families face in today's world. So,
we also have a CPS, someone from the CPS program, if we
that'd be great.
Want to bring her
I
up.
think Representative Dean has a question.
Thank you. And thank you, Ms. Bowers. And that's why this bill is neutral. This is a situation where when statutes and laws were written, we didn't have some of these type situations, and today we do. So it's to basically try to set some things in statute. And again, I didn't really want to get into a lot of hypotheticals, okay? Just trying to find the best way to address the specific case. And I said at the beginning, if there's some, I'm open to clarifying language. If Mr. Tallarico has something he'd like to, talk about there, we're willing to listen to that. But again, it's basically trying to, not get outside the boundaries of trying to give, from a statute perspective, some direction to the courts. That's not a reason to have someone lose custody of their child. And again, we're dealing with, in cases, you have teenagers that go through this, and you also have some small children that go through this. So happy to hear if you have some additional information or clarifying.
Do you have any response for that? Otherwise, I think we were going to switch out.
Yeah, no,
witnesses, so.
I don't. I will politely yield to my colleague here.
And if you, for the record, if you'll state your name, who you represent, and your position on the bill for us.
My name is Liz Cromry. I'm with Child Protective Services, and I'm a resource and so on the bill.
Thank you. And Mr. Dean, first, did you have anything to add, I think, to what Mr. Dean was speaking about, and then if members have questions?
I just brought up the response to the numbers that the representative was asking, and there were 251 allegations of emotional abuse in fiscal year 2018. So that's what our general counsel, Ms. Carmichael, was saying, is that it's on the lower end of in terms of commonality.
Representative Shine has a question.
Emotional abuse based on this gender issue?
No, sir. Emotional abuse
In general?
in general.
Mm-hmm.
So defining emotional abuse, not just from the parents, it could come from outside as well, couldn't it?
Well, our jurisdiction is typically in the family. It could be a member of a household as well, but
So you got kids
not
at
from a
home, and
stranger.
emotional abuse can be, based on experiences that child has at school, with friends, in the community, and come home, talks to mom, talks to dad. They have a discussion, guidance comes from maybe mom a little different than dad. That could all fall into being emotional abuse, couldn't it?
It could.
When we're looking at emotional abuse, we're looking at the impact onto the child, where it has some measurable impact on that child. So, as my understanding of the bill as proposed is that this specific issue would be the causative factor that would cause that. We don't have that today as a basis for
So as I look at
defining.
this bill, it seems to be pretty black and white to me of what the Representative Dean's trying to accomplish. And it's just basically saying that we private family matters to remain private and prevent the courts from intervening in parents' judgments just based on the handling of a child's gender. And yesterday on another committee that I was on, we had some discussion about gender, and DNA doesn't lie, and so until that child is legal age and able to make its own decisions, there's parent responsibility there for that child's welfare. And any of us that have had children, we've dealt with our children's emotional issues, and I guess you could call decisions that parents make sometimes as to what they tell their child they can do, can't do, should do. Child, I guess, could claim that to be emotional abuse, but as I read this legislation, it just seems to be pretty simple and pretty cut and dry, pretty black and white. That's why I wanted to ask that particular question, that's all.
Yeah, I believe we have several members that want to ask some questions, and so Ms. Bowers is next, and then Mr. Tallarico, and then Ms. Kalani. So Ms. Bowers, please.
Okay, thank you, Mr. Chairman, and thank you for bringing the numbers down and really sharing that information with us. I just want to speak to emotional abuse and the fact that that is not something that people talk about, that they will report. And so sometimes you have to look at symptoms, I guess, in terms of their behavior. And is that maybe what y'all have to do when you have a case like that? When do you begin to look more into if it's emotional abuse? Because I just think if looking at what Representative Shine is saying, and that it is black and white, we would need to determine if gender identity and the denial of it, should be a factor. So I think that this discussion, Representative Dean, is important, because if we take it out, as Representative Kalani says, then the information cannot be used. And I just have to speak up because I know that emotional abuse is real. And people that are emotionally abused do not talk about it. And unfortunately, suicide can be the final, it can be fatal. So I'm glad that Representative Tallarico started the discussion on this, because we want to make sure that I am a parent, and we want to make sure that parents are not abusing their children in any kind of way. So thank you for that. That's all I have.
Thank you, Representative Bowers. Mr. Tallarico, I believe you had questions, and then Ms. Kalani, she's still writing her questions out.
Yeah,
here.
I had a question, and then just a few comments, and then we can move on. You're a caseworker, is it?
I'm not a caseworker.
Oh, you're not. I thought she said she had a caseworker coming up.
I am with Child Protective Services.
Okay.
I'm not a lawyer.
Okay.
I'm on the
Ms.
program
Cromwell,
side.
would you
Yeah.
just share your title, your job title? I think that's what he's looking for.
I'm the Director of Services.
Okay. To go back to Representative Kalani's point earlier, if there was a demonstrable impact from emotional abuse, like a attempt to commit suicide, that was directly linked to a parent or guardian's unwillingness to acknowledge a child's identity, which is not a hypothetical, is happening all too often in our state, would that be considered abuse by your department?
I think one of the challenges is in answering questions about circumstances, whether hypothetical or real, that are outside of an investigation. So if we use the suicidal youth, for example, if our statewide intake program received a call about a child that was suicidal, there would be a lot of questions. Being suicidal in itself is not something that would cause CPS to go out and conduct an investigation. So I think we have to ask a lot of questions about contributing factors, even in accepting information to meet the definition of something that should be investigated.
So let me rephrase. Could it be? Is it so? In the situation I just laid out, are you able, standing right now, to rule it out that it wouldn't be abuse?
If I understand your question, you're saying if this is all the information that we have, can we rule out or rule in abuse or neglect? I think it takes more than that for an investigation.
Okay, so it can't be ruled out.
I guess what I'm struggling with saying is that for an investigation, for a CPS caseworker to decide this is abuse or neglect takes a lot of questions, takes looking at the circumstances, talking to people in the family, gathering information, and so I couldn't say that would be abuse or that would not be abuse, what you described.
I appreciate that. And the only thing I'll just say, for my colleagues, I think to help crystallize the disagreement, or at least the concerns, is that is that some of us, I think, really do consider this abusive behavior. So when we talk about neutrality or privacy,
Excuse me, clarify the abusive behavior.
Sorry, an unwillingness to identify or to acknowledge a child's gender identity. We consider that
to the
abusive
child?
to the child, abusive and destructive, and I don't mean, I'm not trying to use legal terms, but I say that because if that's our belief, a foundational belief, then the idea of being neutral on any kind of abuse seems worrisome to us at the very least, and any idea about keeping it private also seems worrisome, because abuse is not something to be kept private or to be neutral on. And so that's, I think, the fundamental disagreement we're kind of currently having is, does this rise to the level of abuse? And I think we can have that conversation. That's how I'm viewing why we've stalled out here. Thank you, Mr. Chairman.
Oh, absolutely. And Representative Kalani, you've been very patient. I know you have several questions for our witness.
I do. Thank you. So do you have anything in your manuals regarding emotional abuse as far as like a checkpoint like this equates to emotional abuse?
We have training, we have policy, we have, and I'm glad to, I don't have that with me, I'm glad to provide that for you.
Because on the website it just says that it's emotional or mental injury caused by the parent or caregiver that results in an observable effect on the child. Psychological state, concerns about the child's mental stability demonstrated by mood, behavior, and thoughts. And I think that part of what we're having concerns with is that by denying the child's gender, that would be a form of gaslighting, and that's definitely emotional abuse. So wouldn't that fall along with what your website says?
I'm not sure that I understand what you're asking. Today, the definition of abuse or neglect doesn't reflect any terminology about what the bill is talking about acknowledging or disaffirming gender identity, and we do train our staff on what to look for emotional abuse, and what kinds of information to gather, and emotional abuse is real, and we talk about that with our staff, and have training on that. So,
but would you consider gaslighting emotional abuse?
And would you define gaslighting for me?
It's like saying something is happening that isn't. Like, let's say that I turn the lights down low in the room, and you say, why did it get so dark? And I say, it's not dark.
I think one of the difficulties is all of the factors that have to be taken into consideration for even things like age of the child when you're telling that kind of information, or circumstances, the settings. It's very difficult to substantiate abuse or neglect on just a concrete statement. So I'm not trying to be disrespectful at all. It just the challenge with a frontline CPS caseworker's job is to look at things with enough information to really decide what's going on.
Right. So do y'all use like psychology in order to determine what your emotional abuse is, like anything like psychology studies and things like that?
Are you talking about for the training, or do we get collateral?
To determine like what your metrics are for determining what emotional abuse is for DFPS. Do y'all have like a metrics that says, okay, this definitely would be emotional abuse, this wouldn't be?
I think we can provide some of the guidelines that we give our staff and the training that we share with that. It is very rare, especially for something like emotional abuse, to be able to say always in this circumstances or never in these circumstances.
Mm-hmm. So via Psychology Today, one of the top things is gaslighting, and I think that denying somebody's gender would be a prime example of that, which is followed under emotional abuse. Do you think that that would be a good standard as far as psychology?
I really don't know how to respond to that. I haven't read the article, and I think representing Child Protective Services, we really do not have that acknowledging or disavowing someone's gender identity as the sole basis for determining abuse or neglect.
Okay. In a case, if you were investigating it, would it be difficult for you to investigate the case to its fullest if you did not have all the information?
I'm not sure how to answer that. The more information we have, the better of a job we're able to do with that. I think there are some things where there is information we may not be able to access or obtain.
So if you were prohibited from having certain information and using it to determine emotional abuse, would that be helpful for y'all or not?
If I'm sorry, would you ask that again?
So you're investigating the case, and there's certain information, like let's say this bill were to pass, and part of you would no longer be able to find out if there was a history or pattern of one parent or caregiver denying the child's gender, which was causing emotional abuse to the child, how would you be able to then rectify your case without all of the information?
I've reviewed the bill and analyzed the bill, and forgive me if I'm not reading it correctly, but I didn't see where it prohibited us from having information. I thought it was, if it passed as filed, that it would prohibit it being the basis.
It says that they may not consider evidence regarding whether the party demonstrates a history or pattern of acknowledging or declining to acknowledge the child's gender. So that would mean you would not be able to use that in your case. So would that be helpful or hurtful if you were trying to determine if a child was being emotionally abused?
I apologize. I don't really know how to answer that. More information is helpful, but we will follow what the legislature determines with that.
And Ms. Kalani, you may want to ask that same question to General Counsel. She might have more information, just because they're both resource witnesses. But as you come up, obviously, would you state your name, who you represent, and your position on the bill, real quick?
Audrey Carmichael, DFPS General Counsel, on the bill. I do read Section 4 as the section that applies to our abuse neglect investigations, and I just read that to say abuse does not include a person's willingness or unwillingness to acknowledge a child's gender identity or expression. So, of course, to this body to decide whether to leave that in or not, but I don't think it says we can't consider it.
I was actually referencing the first part, under acknowledgement of child's gender. It's on the first page, and it's under the amended amount, and it says that the court may not consider evidence regarding whether the party demonstrates a history or pattern of acknowledging or declining to acknowledge the child's gender.
Definitely. I don't mean to suggest that that would not bind the court in that sense, but just wanted to say, as far as our abuse neglect determination goes, it doesn't appear to bar us from considering the information altogether.
Well, the court couldn't. So if you were going to go into a court case to determine whether or not something should be changed with the party's custody, then you would not be able to use that information.
Right. This Chapter 153 would govern all suits affecting the parent-child relationship, not just those pertaining to us. So if we were looking at the question of kind of at the tail end of our case, the final order, who to name as the managing conservator, that would be true. But in terms of our authority to get a removal, whether we would be named managing conservator under Chapter 262 of the Family Code, I don't necessarily read it as governing that.
But it does in a court case.
Yes, for the conservatorship determination under 153, yeah.
It would prohibit that information.
Yes.
Okay, thank you.
Ms. Bowers, you acted like you may have had a question earlier. Do you still have a question? Okay, and then Mr. Teller, does any other member have questions for our two resource witnesses that we've visited with? Mr. Lopez.
Thank you, Mr. Chairman. It may have evolved into a question, but it's really, I want to give you a thought and then kind of help me clarify it a little bit. I don't know exactly who said it, Mr. Reed, maybe it was you or someone in laying out the case that this is kind of a new thing that we're dealing with. What I would suggest is not a new thing in our society. And how we deal with it this time is simply going in and trying to, if you will, give some structure around how it should be dealt with. And that's where I'm struggling with. Does this prohibit or does this enhance our ability to deal with a situation that's really been in our society forever? I mean, this is not new. I think the reluctance for people to accept or not accept maybe it has gotten a higher profile, but it has always been there to some extent. I think the other suggestion is that there's some things that are kind of obvious, that if an unfortunate circumstance produces a suicide, we can go in after the fact and say, wow, we should have identified that. But that's the extreme. There are many other, I think, forms of the abuse of that child manifesting itself, as simple as simply staying in the closet. simply having to deal with that in a secret environment, simply having to deal with that internally and not being able to share with anybody. To me, that's also abuse of some sort, right? It's a range. It's not as extreme as suicide, but certainly abuse. And that's kind of what I struggle with here. It seems to me that this would prohibit us, we would codify, prohibiting us to be able to consider that. This is not a new phenomenon within our society. It's been there. It's always been there. How we deal with it is simply, as legislators, is how we codify it. And that's what I'm struggling with. I do not believe that putting this language in there helps the situation of being able to extend help and support for the individuals that are struggling. So, again, I didn't know if I was going to have a question in there or not, but that's what I'm struggling with. If there's any clarity you can give me, I would greatly appreciate it. But I just wanted to state that for the record so that I can make sure that I can make the right decision for our community. Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Lopez. Does any other members have any questions for our resource witnesses? Now, during testimony, if we have any additional questions, we can certainly call our resource witnesses back up and ask them any other questions. Ms. Carmichael, thank you for your time.
Thank you.
And just to re-announce to all of those that are present with us today, testimony will be limited to 3 minutes. And we've got a neat little color code system up here. It starts as a green light, and at 2.5 minutes it turns yellow, and at 3 minutes it turns red and beeps. And so to accommodate everyone and all of the bills that will be heard today, we want to make sure that we allow enough time for everyone. Of our witnesses testifying, we're now going to call Will Francis. And Mr. Francis, you'll hear me state for everyone else, if you will please state your name, who you represent, and your position on the bill.
My name is Will Francis. I'm the Director of Government Relations for the National Association of Social Worker Texas chapter, and I'm opposed to this bill. I really do appreciate Representative Dean and his staff. They've been very accommodating. I've spoken to them. We talked about potential language work, as well as Chairman Dutton. Ultimately, I just don't think there's value in this bill. It just does not allow judges to have the information that they need when it ultimately comes to placing a kid and determining if that kid is in the best possible situation. And gender identity is very important and is an emotional abuse factor. I used to work for CPS, and we saw plenty of LGBTQ kids who came into the system because they were thrown out of their homes. They were rejected by their families. They will come into CPS because of refusal to accept parental responsibility. That's how they come into the system. But ultimately, CPS may need to terminate rights, and if so, they need to determine whether or not that child was thrown out for their gender identity. And so removing the abuse situation, the circumstance in this, I think would be incredibly harmful to the long-term interests of a case and could really ultimately harm kids, especially the kids who we know already have way worse outcomes than the peers who are not LGBTQ. I think ultimately we just want the judges to have this information. Ultimately, we do want this to be considered by CPS, and so I just don't think that this language is necessary, as it was very well said, to enhance the system. And I think ultimately this is going to prove more troubling and potentially more harmful for kids who need more support. So I thank you for the opportunity to testify today.
Thank you, Mr.
Vice
Francis.
Chair.
Mr. Dean.
Question.
Absolutely.
So, in your opinion, you think that, man and a wife are going through, a judge is going to determine who has custody or full custody. And so are you saying that because one member doesn't recognize, the gender, or they recognize it differently, that's grounds for the person that doesn't agree or agrees with the biological gender but does not agree with the assumed gender? You're saying that you think that's grounds for that judge to disqualify that parent's custody of that child?
It's my understanding that our court system does not have that as sole grounds now, but that is information that a judge can use. And so what I'm saying is the same way they would look at finances, the same way they would look at other types of emotional abuse, the same way they would look at the interpersonal relationships between the parents and the child, all of that information which is currently admissible in court, which then helps the judge determine what is the best, strongest, and safest place for the child, this needs to be information that the judge can use. So I don't believe it's the only.
So you're
grounds
saying also
used.
that one family member homeschools, one doesn't. That may be ground. You mentioned economically disadvantaged.
No, I said finances.
Financially disadvantaged. So that's grounds for a judge to determine that, Mr. Tallarica, because you're today financially disadvantaged, you lose custody of your child. Is that right?
I never said any of that. I said that
You said if they were financial.
No, I said that it was used when judges are determining best fit. They use a wide variety of information to determine. If any
But
judge
financially disadvantaged is one of those things that you said they could
if there's
use.
any judge out there who's only using financial disadvantage, the financial information as the sole basis for it, then I do not think that is a particularly competent judge.
Mr. Tallarico, you have a question.
Just for the record, as a state rep, I am severely financially disadvantaged.
You wouldn't be here if that was the case.
But I just want to clarify that I don't think gender identity is something people can see differently. There's only one person who can determine a child's gender identity, and that's the child. But can tell us, because I know there's frustration that we've spent a lot of time already on this bill and it's late and people are tired. But talk about the epidemic we have in this country and in this state in homelessness, in suicide, in depression with our LGBTQ youth in Texas, and especially our trans kids.
Yeah, if I can, the 2010 National Transgender Discrimination Survey, which was conducted by the National Center for Transgender Equality and National Gay and Lesbian Task Force, reports that in Texas, 85% of trans kids in elementary and high school experience harassment. 46% say harassment from this group is so prevalent that 11% of these trans kids have stopped going to school altogether. This is sort of that larger emotional abuse that Representative Shine was talking about, but the reality is emotional abuse as it pertains to CPS is only from the parent or the caregiver upon the child, and it is often being thrown out of the home. We also know that research from California, and I apologize, I know that's a four-letter word here, but found that more than 30% of the youth surveyed who were living in foster care identified as LGBTQ, even though less than 1% of the whole total population between high school was in foster care. So we know there's such an inordinate amount of these kids who do end up in the system which is already set up, not to support them always, and so we need to make sure that we do have the best means to support them.
Do you, Mr. Chairman, just a follow-up question. Do you think the willingness to acknowledge those kids' identity is a life and death issue?
Oh, very, very much so. And I think you'll probably hear from some witnesses today who have actual experience with that, so I would not presume to speak for them.
Thank you, sir.
Are there any other questions for Mr. Francis? Thank you for your time.
Thank you for the opportunity to testify.
At this time, the chair calls Claire Bowe. And I may have mispronounced your last name. Is it Bowe or Bow?
No, for the first time in a very long time, it was pronounced correctly. Thank you.
Bowe. If you will please state your name, who you represent, and then your position on the bill.
Yes, my name is Claire Bowe. I am an attorney, and I am speaking today on behalf of the Transgender Education Network of Texas and for myself. And I am here testifying against the bill.
Thank you.
I am an attorney with over 36 years of practice in law. 15 of those years was in family law-related matters, first in private practice and then after that in the Attorney General's office. I'm also a trans woman, and many, many years ago I was a trans child. So I know about these things very personally. I have provided information to Chairman Dutton's office, reports from the American Academy of Pediatricians relating to adolescent suicidality among trans kids. What that information shows is that overall, suicidality among trans kids is higher than anyone in the age group. Male to female trans children have a 41% chance of attempting suicide before they turn 21. For female to male transgender children, that number rises to 50%. Now, the bill today is talking about gender identity, and it's looking at this in, honestly, a very even-handed way. I know of judges. I have had parents come to me to tell me the judge took their child away because they were supporting their child's gender identity. And they wanted to know could something be done about that. There are others that apparently have been denied because they did not support their child's identity. I don't want to talk about any of this in terms of abuse. It can rise to the level of abuse. But many times that's not what it is. I'm here today because I get the calls. I was driving to do a presentation at the Poverty Law Symposium, and I got a call from a woman who had been in the office with me at the AG's office 16 years earlier. I didn't know her well. I hadn't talked to her in any of that time. But she knew I was a lawyer. She knew I transitioned. And she called to tell me that her daughter was in the hospital. Her daughter was transgender. And the night before, she had drunk a bottle of household cleaning solution to try to kill herself. The reason that child did that was because the child's father was refusing to acknowledge her name, her pronouns. The child's father would refuse to allow her to have her clothes when she visited his home. The child's father refused to talk to her about puberty blockers that would allow her to postpone her puberty. She was entering puberty, and every day she felt changes in her body that felt strange, wrong. Her hands and feet were growing in ways that did not fit. There was hair growing from places that she didn't think belonged in her body. And that was why she felt so bad. I talked to the father. He wasn't a bad guy. I don't think he was abusive. He simply didn't understand. He felt like he could just hold the line, say, well, this child will be 18, and when the child's 18, they can make their own decisions. But and before that time, that child is going to change.
You're out of time. I would ask you to wrap it up with your final thoughts, please.
So when a judge has this information, I don't know if they should consider it based on just gender identity, but when that judge hears evidence that that child has a 50% chance of attempting suicide in one home, I think the judge needs to know it, because he could be signing a death warrant.
Thank you, Ms. Bowe. Members, are there any questions for Ms. Bowe? Thank you for your time.